Okay, here's a review video to go over some of the major concepts from the first week. As you'll see, I wanted you to start with crime and to try to start to connect those to the learning objectives. This is a core class within the criminal justice major, and so I want to try to provide a social context for how judges start to make decisions about crime, deviant behavior, and how that also relates to other issues in the legal system. So a lot of what you were doing was really just reviewing information, learning how to take notes, how to annotate, how to ask good questions, and how to critically reflect. So we want to see, how did you do with that after the first week, and then I'll give you some ideas about why things might be a little bit surprising for a lot of students in their first week. So, at the basis, when you think about policing, we want to start to think about not street-level policing. In this class, we want to start to think about towards what you might call the end of policing, which is where they're trying to close a case. And so one of the standards for criminal investigation here is CORE, which is collecting, organizing, reporting, evaluating evidence and information. And so how are they spending most of their time then, according to the statistics that I provided to you, is they're collecting and organizing information, evidence about property crimes, including larceny. And so you want to think about that's how they spend most of their time, right? So most of the crime is actually, not violent. And so most of the issues that come up for policing as far as getting into the court system are going to be dealing with property and larceny. So this kind of goes against a lot of people's, two very kind of preconceived notions that you have coming into a class like this. If you watch the news or you pay attention to social media, you think that crime is up. And of course, it's always with a grain of salt, right? You could say, well, crime is up this week as compared to last year this week, right? But if you look at it in the big picture, statistically, violent crime is way down, right? In other words, regardless of what you do in kind of the snapshot, if you want to look at the big picture, violent crime is down, and that also kind of explains, again, why police are spending more time on property crime and larceny. And again, larceny is not violent theft, right? So it's shrinkage. If you work at a retail shop, right, employee theft would be included in larceny. So then so what's strange about this is that considering that there aren't that many murders relative to the larger property crime committance, right? And that violent crime is going down, you would think that the declining homicide rates would be going up because there's fewer violent crimes for police officers to have to try to investigate. But what it turns out is that, there's a social explanation for this, is that there's two issues. There's the lack of resources to the courts to provide funding for witness protection, which in the defund the police schematics, this is one of the things that would be reallocated, would be to actually providing money to people to testify and to protect them against a violent reprisal for being a witness. So that money was not defunded, right? So, or in other words, the police still continue to get the same amount of money, and so there's still not enough money for witness protection. And then there's also this issue of trust and unbiased policing. People don't think that the police are going to represent their interests. They don't think they're going to be protected, and so they don't cooperate with police. So this makes it very hard to solve murders if you don't have witnesses and if you don't have people that are willing to give you information because they don't trust you. And so this social issue is coming into play here. So then I want you to think about, your preconceived notions of murder, and what you should see there is that there isn't one standard definition of murder. Even in what's called the Model Penal Code, only 3 states have entirely adopted that approach. So murder has a lot of different definitions, and you'll kind of see why. But the one I provided to you, it gets you to start thinking about the court system as opposed to what you're regularly thinking about when it comes to the act of murder. And so the issue here in the court system is whether there's going to be evidence beyond a reasonable doubt. And so Danny selling fentanyl to a group of school children, knowing at least one of them would overdose, you can confer, right, as a jury member, you can confer that there's going to be enough information there from the evidence that's going to be presented that Danny had good reason to know that one of the children was going to die because of this product, fentanyl. And so this would be, right, an intentional or a purposeful killing of another human being, or it could only simply rise to the issue of manslaughter, meaning that maybe he should have known, or the reasonable person should have known that this would cause a death. However, the three other examples, and you'll see the most popular one, is John walks into a bar and shoots the man who he just found out was sleeping with his pregnant wife. Now, I'm certain what you're looking there is that, well, look, he walked into a bar and he shot somebody. But that doesn't reach the level of murder, right? Again, we're going to intent, and in the other tradition of malice, right? So did he premeditate the murder, right? He just found out that this person was sleeping, so this could be a fit of rage, is the defense that's raised here. In other words, is there a reasonable doubt that he didn't purposefully or knowingly kill this other person? Did he form the kind of intent necessary under the law to be charged with murder? This is an open question. This isn't a settled issue. And so for those of you who said 52%, point blank, right, as a matter of law, you're wrong. However, let's say you're on a jury, you might be able to convince other jurors that he should have had it. But as the law stands now, seeing red or having a passionate, a crime of passion, is a reasonable defense. It does raise doubt as to whether the behavior was intentional. Tanya using a piece of broken glass here is clearly an example of self-defense. And so again, it's not that she didn't intend to hurt the person, it's that there's a reasonable doubt that she didn't necessarily intend to kill the person, or that her intent was malice, right? That there was murder or premeditation behind this. And then this other one is kind of a easier one, I thought, but a couple students got this wrong, is that clearly this isn't murder, right? So peering into a window might be bad, it might be a deviant behavior, but it clearly isn't murder. The second issue here is that even if you wanted to try the person, I mean, what reasonable expectation of privacy would you have if you were leaving your windows open, right? So somebody looking into a window that's open, doesn't have any curtains, I don't think that should be a crime, right? I don't think that should be, personally, but you might disagree, right? You might think that should be a crime. But again, under the law, it doesn't meet the requirements. So then I wanted to see, how well then could you apply this reasoning to the issue in Eric Gardner? And many of you got this wrong because you focused on the wrong thing, right? What was the cause of the death? The cause of the death of Eric Gardner was the chokehold, right? So for those of you who put chokehold, you understood that this is the cause of the death. Now the question would be, does this reach the level of murder, right? So did the officer intend to kill Eric Gardner with the chokehold? Well, this is a lot like that Danny hypothetical, right? I mean, would the reasonable person know that a chokehold, which is banned, which is not allowed to be used, is the reason for it not to be used is because it's likely to cause death? And the answer, of course, is yes. But again, this would be an issue for a jury. So I want you to imagine now you're a jury and start thinking about these questions. Right? Because what you're seeing here is that this pie chart, these statistics show you that different students have different answers to these questions. And so the first issue here in this first set of questions is, him saying, I don't know, well, that presents a reasonable doubt as to intention. There's also no indication in this statement that there's a death here, right? There's an injury, but there's not a certainty of death, and so, right, that wouldn't meet the level of murder. Again, that's the same situation. The second one is that I shot her, but again, so you have intent, but you don't know anything about the death, so you don't have any evidence of a murder here. Same thing again with the third one, but here you have no intent or death, right? You have somebody who you could have formed intent, right? You could have up until the moment that they don't execute the person, and so therefore, right, you don't have any evidence of intent. Now, lots of people say, well, what were you doing in the closet with a gun? Well, there's a lot of explanations that could raise a reasonable doubt there. Perhaps they know each other. Perhaps they're the key to the apartment. Perhaps the issue becomes more complicated when you start testifying, or having witnesses testify, right? I mean, there's lots of information here that could start to strip away the intent. But the fact that there's no death means that there's no murder, right? So there's no reason to go to trial. The next one is confusing, right? Because it seems like, how would you know? However, again, this is a foreseeable cause. If you push somebody on the subway, regardless of who ends up falling on the tracks, right, it's foreseeable that someone could be killed. And so in this case, this could be charged as murder or could be manslaughter. This goes again to that Danny example, should the person have known. The next one is, it's interesting to see some of these students pick labeling, because what on earth does it have to do with the court? It's great criminological theory, great for an intro to criminal justice class, about why society does this and why people feel this way. But labeling itself as a sociological theory doesn't have anything to do with the legal elements of murder. And again, here in the second one, we've got a statement of law, right? So it's not necessary for the prosecution to show that there's an express agreement between two alleged conspirators. So that's something the prosecution does not have to provide evidence for. The other two are moral belief. It's something that you might think is true, but it has nothing to do with the law. And then the third one has to do with civil liability, not criminal defense. And so this would have to do with car crashes, negligence, things like that. And then finally, I want you to think about juries determine facts. And so that's what I've been giving you these examples of. But judges rule according to laws. And so being drunk was a crime considered equal to other crimes at one point. That's because legislators, right, people who we elect, they go to the capitals and then they write a crime, right? So they write what they think a crime is. A crime becomes a crime because legislatures write it down, not because it's moral or because a certain number of people believe in it. The other thing here is that, well, I'm sure there's lots of people who'd like being drunk to be an excuse. There's this old Latin saying, which means ignorance is no excuse of the law. And then being drunk aggravates violent behavior. A lot of you push this. Sure, that's true for some people, but it's not true for lots of people. I know a lot of people who, when they drink, they get really sleepy and they go into the corner and go to sleep, right? So that's not violent behavior. Again, even if you believed this, it doesn't really have anything to do with the law. It has nothing to do with being charged with a crime. And then the third one that a couple people picked, I'm just not sure why would this be so, right? Well, why would a crime be a crime until abolition was overturned? Meaning, why would making alcohol legal make it so that it's a crime? There's no relationship there, so I'm not sure what people picked on that one. But here I just wanted you to see the difference between facts and laws. So this leads you to the idea that crime is based on what those in power consider to be deviant or to be different from the majority norms. And so crime is socially constructed and it's politically based. So in this recent case, overturning Roe v. Wade, the court, or Justice Alito in particular, goes to kind of excruciating detail, going to historical references before the Civil War to establish that there were criminal principles, criminal norms that applied both to the procedure of abortion, meaning the doctor performing it, and to the woman undergoing it. And they use, again, this very similar to the Daniel hypothetical, where if a doctor gives a woman with a child, with a pregnant woman, a medicine in order to give an abortion, then the doctor would be guilty of murder if the woman dies. Now, this is a stretch the way he used it, but it does show that crime changes from time to time, right? It is not consistent over time. So the deviance from majority norms are not decided by us, they're decided by the people in power, right? By legislators who write the crimes. And so you saw a great example of that now in this recent Supreme Court case. Now, this goes now to another myth that I wanted to try to deconstruct, is that on TV the lie detector test is like the gold standard, but we don't use the lie detector test in courtrooms. And so the correct answer here is that the jury is the best lie detectors we have, which aren't great, but neither is the lie detector kit, which is kind of the joke here. But this is a real product, obviously, for kids, but it's not a reliable source of information. And has been ruled such, that's not included as evidence. But this goes back to the idea of what's the goal of policing, criminal justice, and legal systems. They're to close cases. They're not to find the truth, right? So they're trying to get rid of cases. They're not trying to find out who's right, who's wrong. That's great for TV, it's great for drama, but it's not great for a real actual court system, which we have to spend a lot of money to try to close the case, not to find out who's lying within 30 minutes or less, like a TV show. So why does this matter? Well, look, I mean, the hard part is that when students start learning about law, the first thing that they have to do is you have to not only start to learn about laws, right, the hundreds if not thousands of laws, but that you also have to start disconnecting that from your emotional responses to issues, what you think is right and wrong, what you think are moral, but also what you think is right. So a good example was in the statistics I gave you about guns is that, you know, again, going to social media and the news, you would think that people are killing each other all the time. Now, certainly people are killing each other more than we'd like them to, but in reality, statistically speaking, guns are used for people to kill themselves, something that doesn't really get talked about much in the news at all or on social media. And so, you know, that really kind of messes with people at first, right? They think, well, wait a second, this isn't what I thought. And so it makes it a lot harder to learn about legal reasoning. It's because it contradicts a lot of your prior assumptions about things that you thought you knew. And the reason why that's important is that to think like a lawyer, to think like a judge, you really have to start to like de-educate yourself, right? You have to start unlearning things so that you can relearn them through the eyes of the law. And again, I think another good example was the homicide clearance rates, right? One student said, well, you know, maybe because the murder rates are going down, that the clearance rates would be going down. But that really doesn't make any sense, right? It sounds intuitive, two things going down, so maybe it's true. But with fewer murders, they should be solving more cases, not less. And so you have to look at the social reasons and have a bigger context, which comes out from a legal analysis that would be different than your pre-existing assumptions. So then that leads us to this idea of, so how on earth do students in criminal justice learn, right? So I thought it's great that most of you got this correct, is that, you know, on the one hand, we have to apply it to your real life experiences, your lived experiences, and then on the other hand, we have to try to confront some of these things that you thought you knew, but they turned out not to be accurate. So we have to try to marry these two things together and hope that they kind of form into a new perspective, a new way of looking at things. The main two things I think that you have to kind of just pick out here is that law is not one thing, right? And so the idea that law is just a set of formal rules that everybody has to follow, or else there's going to be a consequence. Yeah, it is that, but it's not just that. It's a lot more than that. In fact, it's very little of that. Otherwise, it would be unnecessary if everybody just followed a set of rules. The problem is, well, what do you mean by rules? Which rules? Whose rules? Who gets to make the rules? There's lots of different issues that come up when you just start thinking about it that way. But it also can be seen as domination and resistance. So one group is trying to control another group, and other people are trying to say, well, that's not right. I have the freedom from harm, that you can't do this to me. And so we want to start to think about it as constituted of multiple legal identities, which is what you're going to learn about next, is that there's multiple different ways of thinking about legality because of people's lived experiences. And then you want to start to think, the second thing is that lawyers and judges, right, so thinking like a lawyer, what we're doing is using legal reasoning from principles and conclusions that come from previous cases, that come from previous, what are called treaties, they're books about cases, but those are within the limits of professional norms that are learned in law school, that every law student is taught, but also in the daily practice at work, as lawyers are working with other lawyers, right, as judges are working with other judges. And just try to remember, judges are lawyers, right? But the other thing you have to think about is it's also adversarial. It means that there's two sides arguing that the legal principles, the same set of books, the same set of rules, support their position and weaken their opponents. So those two things can't be true at the same time, right? And so what the judge really is trying to do, and what juries are trying to do, is trying to see, okay, which one is more consistent over time. And that's, again, going back to the Roe v. Wade discussion, this is why there's so much disagreement, is that there isn't one answer. There isn't one correct answer, and everybody is just wrong. It's that there's variability, or what's called malleability. It's able to be molded based on a lot of factors, and you see those factors here in bullet points. And so this is what you're going to be learning and what the kind of goal is for you to be able to show me that you understand by the end of the term.